give you so much time. They're breaking their.
Good afternoon, everyone. Welcome back to Housing and Commerce. What am I saying? Housing in general or general and housing.
Closet.
Cameron's. And today, it's still February 12th, 2026, and we are live. All right. We're continuing our discussion of H772 and other housing, 886, 688, 772, 440, etc. What I want to, there's many issues, but we're working our way through them. And what I would like to deal with now are some, well, I'd like to deal with application fees. Okay. Current law basically prohibits application fees, correct, counsel?
Yes, sir. I'm just trying to get to the section.
772 explicitly allows there were ambiguities that we were asked to clarify. Here it is. Take a look. Current law.
So it's, a landlord or landlord's agent. Back up for the record, Cameron Wood, Office of Legislative Counsel. This is section 4456A, residential rental application. You can see that the landlord shall not charge, this is in section A, shall not charge an application fee to any individual in order to apply to enter into a rental or residential dwelling. Doesn't apply to a commercial or non-residential dwelling.
Okay. One of the questions that was asked was, well, what about credit checks? Perfectly, I thought, legitimate question. And what 772 does is says that a landlord can charge for a credit check unless the tenant provides, pays for the credit check and gives it to the landlord. Unfortunately, I put the word nominal fee, which I wish to withdraw. I don't think I meant nominal means nothing. I mean, it just doesn't have a meaning. So I would just say fee for a credit check, whatever it costs.
Creditworthiness and background.
What?
Creditworthiness and background.
Not background, creditworthiness.
So the current language in 772 defines what an application fee is, and it includes a background check, so it would exclude.
Yeah.
It would exclude charging for a background check, but it does say you can charge for a credit check.
We're just starting and
Do you have an opposition to a background check? Because typically they do both. They charge and they do both.
I'll tell you everything I know. I do not have strong feelings about this. I do feel like, on the one hand, I was specifically asked by a number of landlords to clarify that that a credit checker is essential. Okay. And it's not that much money. I mean, it's not that.
$65.
What?
65.
Yeah. But I was also told, and I think we heard it, that there's a tendency to try to get around this section by including a lot of what were called junk fees.
Right.
What are they? Like what?
Yeah, junk fees.
Like for what?
Oh, you're asking me?
Mhm. Well, what do they call them?
Like what's the real term for them?
What are they?
Anyway,
Can't
I don't have
remember.
strong feelings about this. I don't know how much a background check costs.
$65.
No,
For both.
credit check for both.
Oh,
They usually are combined. Most people, I mean, I'm sure there's some places that may do just a credit, but they probably
Right.
charge the same thing.
Sure.
Having talked about this issue before when it was raised, part of it was a fairness issue because if I'm taking 15 applicants, just like we talked about before, you can pile on all the costs you want to a landlord that's just going to go in part of their equation for how much rent costs. Well, in this situation where you can charge the person the exact cost for a background and a credit check, that person pays for it and not everybody else applying or that's going to be living in the building. Doesn't get dispersed amongst everyone else. It's just the person applying for it pays that fee.
This is important because just to genericize this, it's not enough to be in favor of something or opposed to something because it's going to be passed on to everybody. That's social. That's called
Yeah.
socializing a cost. Some costs should be socialized, but others not. And what Joe is saying, not this one.
Correct.
So
Okay.
what's the will of this group? Shall we put in the next draft of 772 background and credit check, or credit check and background? Take out nominal, just whatever the cost is?
Yeah, I would tie it to the actual cost of, because I'm
Yeah,
guessing everyone doesn't use the exact same company to do it. Some like
Right, remember
$8 month.
CHT testified one year about that. They use a big company and.
Yeah, so if you can, if a tenant wants to say like, show me the fact that it costs $90 and you cost $90, let's pick up.
counsel, do you feel you have your instructions on this issue? Debbie,
Well, I mean, really it doesn't apply to the stuff we do, but you know, and that, there's no application fee. So, you know, you might have 20 people apply for a place. But it doesn't mean that you're gonna be doing checks on every single one of them. You might say, this
I'm only
person
gonna
got here
look at- I'm
first or
only gonna
whatever,
look-
and whatever the case may be, and then you might go on and do your checking.
Yeah.
Right.
But I believe actual costs, I go with that,
yeah. Okay,
So what are we doing?
actual
What are
costs.
his
seven
instructions?
72 plus background check.
Credit check and background check, you can charge no nominal fee.
Take out the nominal fee, just the actual cost. Then we have, this is a little stickier here. And again, I've received I've looked at a number of the letters I've gotten. Habitability, okay?
Yeah.
Current law, and I'm waiting for council to. Current law says the landlord has to provide a habitable place. And it limits, I think it defines that as having heat and water. Is that right?
Those are the two things that are specified in the statutory section, but you have the Division of Fire Safety that have implemented their residential dwelling unit rules regarding habitability.
Right. Okay,
I have a question.
yeah,
I had a friend who was living in an apartment that didn't have like a working oven or things like that. Is that specified in any way or of the responsibility of the landlord for habitability, or is it just heat and water?
well, it says
Toilet?
habit, what's it say? It says no rental agreement can,
This is just the statutory section. I can pull up the rule.
any such waiver, yeah. As part of the implied warranty of habitability.
I don't think we need to change that.
No, I'm not proposing
Oh,
to change it, but however, 772 adds a defense to ejectment where there are major code defects, and they are listed. Other states do this. Hi, Saudia, can you hear? She's probably still connecting. 772 does what a number of states do, which is they allow a defense to an ejectment action to be a serious code violation. The concern I had when this was drafted is I didn't want it to be just any violation. Because I know from my own experience that you can have the most trivial kinds of problems. You know, your step is a half inch, one step is a half inch bigger than everything else, or whatever. And I didn't want that to apply. So what we did is that we actually went into regulations that the Vermont State Housing Authority uses, and it lists really serious violations. And I put that in 772. Can you call that up?
Yes. Just a moment.
And there's a problem with that I have received we've received further comments. And I want to lay the whole thing in front of you guys to discuss. Let's see where, this is
It's on page 10 of 772. It's gonna be on page 15 of that side by side, the other side of Richmond Hill. It's gonna be the gray side by side. And I'm gonna pull it up on the screen.
Did you read more?
Yeah,
Possible.
I can't beat it.
Don't do that. Okay, so there are two issues before you. One is, what do you think of the list? The intention of the list is the kind of stuff where you just common sense tells you this is not a good thing. You know, you really can't have this in a unit. However, here's the problem that was various people mentioned about this list. A number of landlords have testified or told us that the first time they hear about these problems is during eviction. You know, the tenants don't inform them. And of course, we're not aiming at the landlord who is, we don't want to include, this is a classic case of not wanting to overcompensate. We want to give an eviction defense when we have a landlord who's really doing a bad job of providing a habitable place. So and also we don't want the tenant just sort of coming up with some minor code violation during eviction and using it as an eviction defense and causing a much lengthier proceeding. So the simplest proposal that I got was that it has to be in the form of an actual code violation. What's the word? You know, a ticket that there has to, what is it?
Citation?
A citation that has been uncorrected and that this prior to the eviction.
Mhm.
Right.
Prior to eviction or prior to, isn't this the person, the rentor, wouldn't be paying their rent? Because these things are also not.
That might be, but I'm saying that, remember, this whole section only deals with after an eviction notice, an eviction case has been filed. What it's not changing the warranty of habitability. It's not changing the habitability section. All it deals with is it's an affirmative defense in the case of an eviction.
We're not paying.
We're not paying rent.
Right, for not paying.
We're all,
Okay.
Right, yeah. for not paying rent. And there, I think it should say that it has to be an uncured citation where the citation occurred as of the date of the eviction.
Landlord's gotta know that was problems.
Yeah. Because what I heard from landlord's counsel is that if there's an eviction notice, you know. Not eviction, excuse me, if there's I keep forgetting the word, a citation
No, from the,
from, you know.
right, yeah.
Right. So what are we,
From asking how people feel about
so the only changes,
it. I would add that there has to be
An unresolved citation.
an uncured or unresolved citation, yeah.
Yeah, I mean, that makes sense knowing
Makes sense.
that would be frustrating to show up and be like, well, this is the first time I've heard about that, so.
Apparently, that's rather common.
While you're reading, I can comment and looking at the rules, at least as far as I can tell at this point.
For habitability, you mean.
Habitability.
Oh, yes, please.
The Division of Fire Safety, it says that every dwelling unit shall contain within the unit space to store, prepare and serve foods in a sanitary manner, including the presence of a kitchen sink. Doesn't say that there shall be a.
right, because you could have a hot plate too, people have those.
So, but that is what it says. It's
Okay.
Sanitation and kitchen facilities.
That's good.
Mr. Chair, you have a question?
Thank you.
Yes.
So are we trying to, that's the existing
No,
law? Okay,
that's 772.
okay, so are we
All the
attempting,
underlining means it's proposed.
right,
Yeah, I'm just trying to see where everybody is on this
I think it's good.
I think it's good.
with the change.
Yes, a citation.
Okay.
But I just have a question about the content.
Yeah,
Is
we can
there,
change
is
the
there
content.
something,
What?
is there something that can say, as an example, if there's mold, like one sentence that covers something that would be hazardous?
It
Somebody-
says- I thought there was a catch-all.
Yeah.
Well, it
Conditions.
includes all these things, yeah.
Yeah,
Mold would be a health and safety code violation.
yeah.
Hmm.
It's also, if you dig it, I bet 45% of the homes have mold, if you really check.
I think
It's
what they
That's
do-
what we-
like black mold,
I
yeah.
think what they do,
Yeah,
they require fans, like a exhaust fan in the bathroom.
yeah.
Oh, well, yeah, smoke detectors, but I'm just saying when people talk about mold,
Oh,
it's
So
usually
that health
found in
and,
the
I didn't
bathroom.
see that there, the health and safety covers
Yeah, that would
things like
cover it.
floorboards being, you know, dangerous or mold or whatever.
I have one question on this list.
Yeah.
H. How on earth do you regulate that? Like fixtures, like you built in a built-in cabinet? Like, There's times when my
you have
front door
to,
has something
you know,
in the way.
in my understanding, fire safety code requires certain egress from, dwelling rooms within.
but it just has to be that the landlord didn't put it there.
That's how I read. So there is a section here that says that, so right here too, the tenant,
Okay.
the tenant cannot use this if it is their deliberate or negligent.
Okay, so if they put a hutch in the way, okay.
Right, yes, if the tenant puts it there.
There you go.
obstruct the-
Okay, I'm just like, that's a bit.
I think that.
Train your,
I could jam my door.
train your dog to
Is
stay
add to
there.
the-
Jam my door.
Add to subparagraph 1, just where it says serious health and code safety violation that exists as of the time.
Yeah, okay, thank you for that.
Okay, any
Not
other
reading it.
questions on this section that people can think of right now? I'm going to raise a couple of other issues that aren't that, I don't think, difficulty. there's a $1 million appropriation for the down payment assistance. The Vermont State Housing Authority Down Payment Assistance Program, remember that one was funded with a $2.5 million one and is pretty much out of money. Kathleen Burke testified to this. So we're proposing a $1 million appropriation. Whether that's there or not, I don't know. In other words, whether we'll get the
Whether
1 million.
we'll get it.
Whether we'll get it or not, but I'm proposing that we ask.
Yeah, sure.
That program is often, as I understand it, am I right, council? That's a program that's initiated by landlords. Is that the program? I think the landlord and the tenant have to want it. It's not like,
I think it can be initiated by either, but they
By
both
either.
have to sign on to
they
it.
both have to sign that. I think
Because it
you're right.
started out like one way or the other.
Yeah. And I also included in 772 a landlord and tenant education program that talks about rights, responsibilities, and remedies. The reason I did this is that, well, first of all, I'm looking for anything that prevents eviction notices at all. And CVOEO did agree, they do already an education program very much like this. They do programs for landlords and tenants. And this asks for $200,000 to do it. They tried, by the way, to get a grant, a federal grant, and they got it. But it was conditioned on their making all kinds of assertions that you can imagine what they were. And so they didn't feel they could do that. But it's a different program anyway. So this is just to try to educate people on the theory that both small landlords and tenants would benefit from. Yes,
I just want to make a comment
yes.
that Spates Realty up in Newport area. He actually goes into the schools and teaches a class on how to read a lease, how to be a good tenant,
Oh, wow.
and what a good landlord looks like. No charge. Excellent.
What is that?
That's a realtor, the realtor agent that does that. One I want to mention. CBOEO also testified. I can't remember who it was. I think it was them. They testified that they would like to see an appropriation for CAP agencies to have rental advisors, remember? I'm just bringing this up. I got to get language to put in front of you. And I think they asked for $600,000 for each of them to have a tenant, educator, ombudsman, et cetera.
A full-time person
Yeah,
for each cap
yeah,
for rental advisor.
Yeah.
Almost $1 million.
it was 600,000, I think.
Is this community action or CVOEO?
It was community, the TVOEO may have, I'm sorry, I don't remember who advocated for it. I think it may have been CVOEO, but it would be for each of the CAP agencies.
Okay.
And I have had a number of people, my first reaction was, what a great idea. Anything that keeps people out of the courts, out of an eviction situation is great. Everybody should like it. But my first reaction was, yeah, like, where are we going to come up with $600,000? And what I was told was, put it in there and see. And so I think, just see if it's a good idea, put it in there, if it's a good idea. I want to just get a temperature check. I will try to find language, because the theory being that something like this, both tenants and landlords should like, if it works,
Right.
to keep people current on their lease, educate them on financial literacy, help people understand what, help I assume part of the role of these people is to do what legal aid attorneys otherwise do at best, but in a much more, what do you call it? An environment that's less confrontational. One of the things that you heard testimony about was, keep forgetting the term. Restorative justice.
Right.
And restorative justice is incredibly efficient. I mean, for whatever it costs, it saves so much more. But that's after, you're talking about when it's already way down the road. This would be earlier. So I kind of like it. And I'm just asking at this point, is it okay with people if I get language and find out more?
And I mean, you can certainly do that, yes.
Yeah, and
I think.
let me know, oh,
Yeah.
let me know how the committee feels about this. I think, yes, certainly get language, but I'd like to at some point, before we keep separately adding in the different fiscal parts to see what all the thing looks like before we rank and agree to what fiscal, I know that there's some people who are really fiscally minded in here, and so I wanna be cognizant that we look at those things as a package, so that seeing like ranking what might be more efficient of fund, right, Joe, like something like that.
Right?
Yeah.
Yeah,
Yeah, prioritizing the fiscal ask in the bill.
yeah.
If it were up to Emily Krasnow, I'd load it up with everything anyone asked for, because I am sure it'd be effective, but I'm also realizing that in these lean times, can't be acting
Right.
like that.
Right. At the moment, right now, it's all on the last page.
Okay,
But that's
I
not in there. What it is at the moment is 100,000 to the state treasurer to implement the positive rental payment credit reporting.
I think we could use that money elsewhere.
Okay. 1.2 million for the Department of Housing Community for 1 million for the rental arrears assistance fund, which council is the wrong name apparently. Kathleen sent us an email I forwarded to you that changes the title. And then 200,000 for the reports.
that's it?
That's it.
So how much is that? Almost $1 million?
No, it's 1.3.
2.
Total.
Yeah, that's
1.3 million
Oh.
total.
I
Yeah,
may have misspoke when I said that. I don't think it's necessarily best to put it elsewhere. I think it's best to have an honest credit report. But as
okay.
opposed to, as I read it, only positives.
I thought that it's not. This was actually, this is not, and what he's referring to is. My memory is that there was a credit reporting program.
Yeah.
And in the
It's
Senate,
not just a credit reporting, it's
Right.
about, it's a credit worthiness.
Right,
It's
right.
It's building your credit
building your
history.
credit
So
history.
it's on you to build it right.
Right. So just to throw out what happened. What happened was, the way it's designed is if you pay, it's reported
Positive.
positive. If you don't pay, it's not reported, but you're out of the program.
Hmm.
That went to the Senate. And in the Senate, a couple of members of the Senate Committee on everything,
Our sister committee.
our sister committee, were really worried about the fact that it wasn't bilateral. They wanted both the positive and the negative reported, okay? But then it was pointed out that the negative was you're kicked out of the program, and they were okay with that.
Yeah.
So it came out, and then it got lost in our housing bill, literally lost. Because remember, they had the House bill, we had the
Oh,
Senate
yeah,
bill.
yeah.
we made the Senate bill the vehicle, and somehow in
Oh.
there, it just got lost.
And they want this too, back,
Yeah, well,
you think?
so I put it back in.
I, s-
I'm not telling you it's.
No,
should change their mind.
I am 1,000% on board with getting rent included as a positive
Yeah.
on there, but I'm also a realist who's like, you know, once you're out of this program, the credit reporting
You're
doesn't
out.
work that way.
Yeah, right.
They don't not report the bad stuff
Mm.
and kick you out of credit reporting because you missed a payment.
I am under the impression, does somebody know that ordinarily rent payment doesn't make it into credit? That's the reason it has to be funded, is that you have to pay the credit agencies to do it?
I don't know.
I don't know. Okay, I'm sorry, I don't know. Let's find a little more.
Let's find a little more about this one, but it's not like a no.
Yeah, no, I understand.
So,
So there was,
oh, my understanding was that like some of the trusts already, the housing authorities are trying to implement this or do implement this, like I know
Yeah.
Chris Donnelly just, is that, so we're talking about that, but
Doing
trying
that
to do it.
statewide out of the treasurer's
Mhm.
office, yeah.
so a few years ago, General Assembly asked the state treasurer to do a report into this, to try to expand on it. So they came back with the report recommending this pilot program. It would be basically at least landlords
Oh, okay.
and no less than 100 tenants to try to do the pilot. So they could come back to you with results and possible mechanisms to then make it a state requirement.
I bet the lenders would love that.
But
I bet the lenders would love that too. Right? You just-
I think it's a good thing for everybody. if they
No, I
do.
like
Yeah.
it. I like it.
Okay, so then, there's another issue or question. The issue is confidentiality of eviction records. And this issue was taken up by the, Judiciary Committee. And they worked out at great length, a bill. The bill had input, lots of people's input, but for reasons that I don't know, and I will find out. It just never made, it was never taken up. I don't think the committee even got to it. I think it just didn't get to it. The issue that the approach of that is that the eviction remains confidential until judgment. If there's judgment, then the confidentiality is lifted. So if someone is successfully evicted, it's public, the agencies can pick it up, et cetera. Here are the criticisms that I've heard on both sides. One criticism on the landlord side is, I want to know right away. I don't want to know only if the eviction was successful. I just want to know if one was filed. Okay. The tenant side is exactly. The problem is that there are lots of situations where the tenants have we've heard two things. One is there's lots of situations where there's a property manager, it's a big property manager, and if your rent is a day late, they file a notice, and then if it's uncured, an eviction, and then you cure it and it goes away and everything's fine, but that's on your record. And if a landlord is faced, well, no, before I get to that. Another was, we had one person in here testifying that, remember, we had a tenant describing a situation where there never was even eviction action filed. It was what was it, a late payment or?
Somebody, organization was covering their rent and
Yeah, so-
pay, so I didn't even know.
Yeah, and all of a sudden it was on their record. And they're pointing out that in a tough market, if the landlord has got two different or more tenants, they're just not going to consider tenants who have an eviction reported. So this bill says it's got to be a serious eviction where it actually happens. And that's, I've now said everything I know about this issue. Yes.
It's not, just so you're all aware, I did not include any of that language or sections side by side because it was. Yeah, you're already at 2 pages on the side, so
Yeah, it's at page,
there's quite a few sections.
quite a
on it.
few sections. It's a long part of the bill because it was worked, all the quirks and issues were worked out. What page is it on? It's,
Yeah, on page
several pages.
18.
Yeah, it's several pages of the bill.
It's on page 18, it goes through page. The bottom of page 22. Mr. Chair, you have a question, right?
Yeah. Debbie.
I was just gonna point out that that first notice, when you do a termination notice for whatever
Right,
reason,
yeah,
that's not recorded with the court. It's recorded once you file for
Right.
your complaint.
right. The assertion, and I'm not sure what to do about the assertion that sometimes credit, that very early notices are, I just don't know enough to address that problem. But this is, just to be clear, this is taken from the effort that judiciary put in, and it's really goes through every wrinkle about how you maintain confidentiality and all of that, and then the confidentiality is lifted. So I wanted to know, at the moment, that's fully in the draft, how you felt about leaving that in the draft.
Why don't you like it?
Probably because it's court record. And I mean, you can find out that things got worked out, and that's a positive. I see that as a positive thing.
But is there a but?
Yeah. I'm not saying that.
Yes,
I think it's solid. One of the things, I don't know about anybody else, I pay a lot rent. It doesn't come out of the bank automatically until the 4th. So I didn't even know that it could be 1 day late. And if for some reason, and I was in the hospital for 3 days, right around rent time, what if I didn't use automatic withdrawal? Then my lot rent would be late, of no fault of my own. Situations happen. So if different, it would be different if it goes to court and I'm found liable, then yes, it should be on my record.
well, also, I mean, Debbie's made the point that there is a certain value to, from her perspective as a landlord, to knowing that a problem was resolved positively. The only thing I can say there is, and I think a tenant can explain that to a landlord, but how do people feel about, I mean, I can see Joe very carefully reading through this, and it's rather long. I'm gonna, because we have other things to talk about, I'm gonna suggest that in the current draft, we leave it in, subject to people spending the time to read it and think about it.
Would,
Fair?
I have at least a minimum recommendation, but
Yes.
I'm happy to take that to the judiciary team if you feel that it is more appropriate for them.
Oh, I think you should talk to the judiciary team about it.
Not my team, the judiciary committee. I should
Oh.
say.
The judiciary committee at the moment may go with a flyby depending on our discussions with Judge Zone.
So just briefly, and I'm not gonna walk through the whole section because of your time, as you said.
Okay, no,
I'm happy to
please.
Answer questions if people have them, but I will just comment, one of the things here doesn't fully make sense to me. This is, so the record becomes confidential at the time it's filed, and then if there is a finding that. So under this 4873, if the court in an ejectment case issues a final judgment after the hearing in favor of the landlord because the ejectments for non-payment of rents, 17, line 17 moving down, or breach of the rental agreement, the court shall remove the confidentiality of the ejectment record after 30 days unless the court orders continued confidentiality pursuant to subsection B. So it's confidential, landlord wins, it's because non-payment or breach of terms, criminal activity, whatever, it loses its confidential status unless it continues to be confidential because of B, which is the court shall order, among lines 1 moving down, court orders the ejectment record will remain confidential if the parties so stipulate or upon the tenant's showing of good cause within 6 months. Showing that the defendant meets any of the following conditions is deemed good cause. A, the person is a victim of abuse. Okay, makes sense. The defendant is a person with a disability, as that term is defined. Okay, that makes sense. Not from a policy perspective, from a legal perspective, that makes sense. C, the defendant is a member of a protected class. A protected class includes sex and gender identity. So in theory, the way I read that is everyone.
I think that's overbroad.
So that's my own.
I take that. I'm okay with taking that out. I mean, it's just too broad, exception.
I mean, it's just like.
Unless there's some reason, they'd have to show that there's they'd have to convince the judge that there's a reason that relates that they should do it. I mean, I just don't want to make it automatic.
This is saying that it would automatically be good cause if
Yeah.
you're one of these, and that's what I'm saying, you're a victim of abuse. I can understand the concept of putting that there. You have a disability, like I can understand the rationale behind doing that, but just saying you're a member of a protected class. Again, discrimination based on sex is a protected class, so it just doesn't fit to me. It doesn't make.
And this doesn't even have to say it's discrimination. It's just you're a member of that class. Yeah,
Right,
I think that's overbroad.
And for those following along, I'm talking about just this section here. So, I will. leave
Where
it
did that
for
come
you.
from?
I don't know.
Cameron,
It's
do you
in-
remember where that came from? The bill or?
It was in
It
the,
came from the sponsor. I'm not gonna share anything unless he wants me to.
yeah,
Oh, the sponsor.
yeah, that
That's
same
you.
one.
Oh, you, that's from your bill.
It's just, yeah, it's just, this is all
Yeah, I
said,
remember.
this is non-existing law. This is.
Right, I didn't know if it was from one of the other.
No. It's just,
This was in your,
Yeah, and
and
it's just-
only yours.
yeah, what I did was I just took the stuff that was from judiciary and legal aid had done some work on it and put it in here. Yeah,
Got
I'm
it.
just trying to understand this, so that when you go to the courthouse and they have posted like what's going on today kind of thing. Are you saying anything that would be an eviction process, like they wouldn't show?
except the parties can see it. I don't know how that, what does it say?
Well, you can go to the courthouse and they
So,
put a sheet of,
The
What's going on
definition,
there?
It's also online.
the hearings. Yeah, so it just wouldn't show up there?
the definition says in this draft language that a confidential record does not limit public access to court hearings. So
So they-
it says all ejectment court hearings shall remain open to the public. Names of the parties shall not be listed on the court calendar. I don't know how those two things would mesh up. If you're
Doesn't
saying
make
you
any
can't
sense,
list
yeah.
it on the calendar, but it's open to the public.
I'd like a judiciary interpretation of that. Yeah, because it's my understanding, because I'm a sleuth, that I look online and I look at court things just to see what's up.
See if it, see if anything was there.
See if anything was there, yeah. And see like what's up, yeah. So I'm struggling to understand like how this, it seems kind of like it would and wouldn't show up.
I don't know how. that
Right.
would
We should
in
figure that out.
practice.
Yeah, we should figure that out. Has the judiciary team looked at this in your office?
They have, yes.
Could
that
you try
area-
to at least get a little clarity as to how this functions in a normal courthouse? Is that fair?
Even I can talk about it, yes. Unless you want me to be open here.
We should talk about it, or you could talk about it.
Let me
as the
talk about it with
sponsor.
you, and I
Yeah.
think we want to try to get, I think these are very legitimate questions, and let's find out how it works. I don't want to run over to judiciary. If they're willing to do a flyby, let them.
Mhm.
I don't want to go there just for this. If we can just get a better
No,
sense of
no,
how
you
this
wanna
works.
work it out in
Yeah.
a different way, so
Okay.
you can meet with the lead sponsor.
And Lord, wait a minute here, education, right to purchase, there was one other.
You wanted to talk about security deposits? No, we talked about
We
those.
talked about security
My apologies.
deposits.
Yeah,
I think, let me just check. There was something, another easy one before we got to something really.
these are the easy ones?
Yeah, these are the easy ones. Trespass.
Oh, yeah, I'm very interested in this subject.
Okay, I am going to introduce this subject by describing situation. And I would like help from those who are in the know. There are different situations. It's not one problem. It's several problems. You care about it, but you're leaving.
Oh, no, I'm asking you a question.
Okay.
Well, I can ask the body, did Rob Goodno's bill arrive yet in here?
No, it's not coming here.
Oh,
All that I said was, don't bother.
okay,
Just if we want it, we'll just take the language.
because I like that
Yeah, I
language.
do too.
Okay.
Okay, I'm gonna describe the situation.
Sorry.
Situation one, each of these situations occurs. These are real problems. A tenant is causing, is undertaking activity which is a danger or to the health and safety of other tenants or the landlord, et cetera. We all know what those could be. The tenant is successfully removed, whether they just leave or whether they're evicted, they're removed. They turn around and come back. And they have someone in another unit and they go in the other unit. Okay? That's one situation. You with me? So you look puzzled, Mary, right?
No,
With
I'm
me?
listening.
Okay. And to put a gloss on it, we have a situation which is apparently, unfortunately, not infrequent, where the tenant who is evicted is a drug dealer. The drug dealer goes out, and then the drug dealer finds another tenant and basically forces them, either because the other tenant, because of violence, or because the other tenant is an addict and they
Right.
prey on them. Yeah. And there they are all over again. That's situation one. Situation two is which Ian's bill is about, is a situation where the drug dealer, to use that example, but it doesn't have to be that, was never a tenant. They're just out there in the world. Same scene. They have some tenant inside, either as a buddy or more often than not is not a buddy, but is intimidated or preyed upon, and they go into their unit, but they were never a tenant. Okay.
So we're talking about page 17 right now, section 3, is that?
Okay, so now having laid out these two situations. On page 17 of 772, there's an unlawful trespass law, and I'm just going to characterize this quickly now and then let council take us through it. We added that if a person enters or remains on any land subject to an order against trespass, regardless of whether they have the consent of the person in lawful possession, land or place, that unlawful trespass action will lie. Whether this covers the second section, the second problem or not, I don't know, but Ian introduced it. There is a case, the Dixon case, I think, in which I've tried to read the case. It's a weird fact situation, but basically it seems to stand for the court's view that under current law, you couldn't deal with the second problem.
Right.
If they've, in other words, it's one thing for a landlord having successfully ejected someone
Right.
to say, oh, you can't just come back. But it's another thing if they're just some outside person coming in and forcing their way in. And the Dixon case said you can't do it. You can't, the landlord can't issue a trespass
Against a
order
guest.
Right.
against
and
the
we can-
guest.
We can have the state's attorney or if you want testimony or a coach just like it, but this is the thing that happened.
And then Ian introduced a bill that says, no, you can. We're overruling Dixon and we're saying you can. And we have the language from Ian's bill, which addresses the second situation. I have now given you the non-lawyers, despite the fact that I'm a recovering lawyer. I'm giving you the non-lawyer's perspective. And I now ask counsel to please correct me or take us through this. And we have the option of having this language, we have the option of no language, we have the option of this language plus Ian Goodnow's language.
So, unfortunately, I had material about this issue and I misplaced it. It's in my office, it's just not
Yeah.
with
Right.
me currently. I think, Mr. Chair, I think you kind of described
Yeah.
the issue, if you will, sufficiently. Keep in mind, we all have constitutional rights to associate with individuals that we choose to associate with. And so the issue is, I
You
understand.
pass this down to council.
I have that.
Oh, you have the bill.
Dixon case with me and some notes, et cetera.
No, but I mean, do you have 728?
Yes, sir.
Okay.
And I'll pull it up here in just a second. So, my recollection of the Dixon case was that, if an individual is voluntarily asked or authorized to come onto someone's property, keep in mind, you're the tenant, that you have lawful possession of that property and you can invite and exclude who you would like to. Because you are, that is your property at that point. It's your home. You have the same rights as other people do and they're single, family residence building. If you recall, you can even exclude the landlord. There's a specific section in the statute about when the landlord can access the property and
Right.
under what circumstances. So how do you deal with the circumstance where it's an apartment building and you have to walk through a common area
Right.
to get to someone's individual residence? And so
Mhm.
that's really what the Dixon case is about. An individual had, some sort of or was being charged with a trespass because the individual was in the common areas going to someone's building or, dwelling that they had been invited to. The court
Right.
said you can't, under the current statute, you couldn't essentially hold or prosecute that individual for walking through a common area to get to a location that they had been invited to. And so I was requested by Mr. Chair, the sponsor of this bill, to, work to try to come up with something that would.
And Ian authorized counsel, remember, counsel is not, when he's representing individual bill proponents, he's not authorized to talk to anybody else unless the bill proponent does. So Ian has authorized him to
Right.
talk to us.
And so,
Okay,
Representative Goodnow had requested a similar bill that was drafted by another attorney in our office. So you have kind of two versions of this that you could look at. So I'll just walk through kind of both of them real quick. I'll start with 772. So this has
Skim up.
after, so this is.
You guys are gonna become experts now in trespass.
This.
Ready?
This 4869 would go in the section associated with the ejectment chapter, so we're still in ejectment for a second. After execution of the writ of possession, so the landlord gets the writ from the judge, giving them lawful possession. The plaintiff may issue the defendant an order against trespass for the entire premise subject to the ejectment action. The order shall be effective and may be enforced with criminal penalties in accordance with the trespass section, regardless of whether the defendant has been invited onto the property by another resident. And
Now,
then-
wait, that's the first situation.
Right.
That's someone who's a tenant has been successfully ejected and they come back. This says you can get an order prohibiting that. Okay,
So then you go to the trespass section itself.
of the code, a completely
This-
different section.
This is in Title 13. This is a crime. This is in the title related to crime. So unlawful trespass, a person is in prison not more than 3 months, fined not more than 500 or both. If without legal authority of the consent of the person in lawful possession, the person enters or remains on any land or any place. And then I added a subdivision 3 here to say, if a person has been issued the order that we just reviewed, it shall be a violation if the person enters or remains on any land or in any place subject to the order against trespass, regardless of whether the person has the consent. So it's just adding that two piece. You can give someone a trespass order if you get the ejectment against them, and then adding into the trespass section that it's not a defense here if the individual has, if someone has invited you onto the property.
Okay, I'm gonna stop you for a second. So this is all about the first situation. This is all about a person who was a tenant. And all that, what council has done is make it clear by the additions that you can file a trespass action against them. And you can file it such that it's a violation for them to come anywhere in the place, not just their old apartment. And it doesn't matter whether they get the permission of somebody. What it does not deal with is the second problem, which is someone who never was a tenant, but is coming on and doing bad things, possibly preying on somebody there. That's an Ian's bill. Okay,
And so just pulling this up, this is the purpose of this. So this is a purpose statement. So this is 728. Adds a purpose statement. The purpose of this act is to overrule the court case in State v. Dixon and allow a landlord of a dwelling unit to obtain a no trespass order prohibiting a tenant's invitees or licensees from entering the dwelling unit's common areas if the invitee or licensee subject to the order has violated the terms of the lease agreement.
That's just.
So it's
the
just
operative
saying,
sections are interesting.
so it's saying that if the individual invitee is violating the lease agreement, then the landlord can get a trespass order against that individual. So someone is coming onto the property and selling drugs out of your apartment. They've never been a tenant.
Yeah.
You're inviting them on. Maybe I'm trying to pursue an ejectment action against you because of that. Maybe you are being preyed upon by someone else. So I don't want to evict you. I'm just trying to exclude this individual. And so then we're back into the Title 13, 3705, which is the unlawful trespass section. So you'll notice this doesn't have anything to do with the writ of possession and getting a trespass order when you get the writ. This is just unlawful trespass. It has the same lead-in language as A, and I apologize, should have zoomed in there. It's the same lead-in language as in 3705, which is not new, but it adds this subsection G here, which is notwithstanding subsection A. For any provision of law to the contrary, a landlord of a dwelling unit may cause to be served an order against trespass that prohibits a tenant's invitees or licensees from trespassing in the dwelling unit or any of the dwelling units common areas if the tenant responsible for the invitee or licensee consents to the order. The invitee or licensee subject to the order has violated the terms of the dwelling unit's lease agreements. Or the invitee or licensee has violated a state or federal law while on the premise of. It could be any of those things. I'm the tenant, you keep coming onto my property, I don't want you on the property. Landlord can get a trespass.
Yeah, I could communicate secretly with the landlord and say, I don't want this person here.
Right,
And then they're authorized, the landlord under this can.
I have
that
to,
would-
I have to go to ag for a
Okay.
minute, but if we do make it, I vote to have the good no language put in. And, if folks would like testimony as well, I can tell you who wants to testify.
Great, okay.
But that's my vote, but
So notice this is or,
There's a-
this list, every time you see a list, since you guys are all becoming ex-lawyers, one of the things you should always remember when you see a law, when you see a list,
Jeez.
is it or is it and? Okay,
So I have a question.
yes,
How do you, I imagine that there's a whole procedure for successfully getting a judge to write a no trespass order, right? Like you can't just say this is happening and
yeah.
it just.
Not my area of law, so.
But you have to go to court, you have to ask the court for a trespass order, right?
We've never done that, but I thought it was through the town. The town police enforce trespass.
They enforce it. But I think you have to go to court to get a trespass order.
Because
It's a
otherwise
criminal,
it's-
it's a criminal thing.
Yeah.
I'll just say we've had both these.
You've had both of those
Situations.
situations happen.
I will get you an answer.
Oh, yeah, thank you.
And so then it says notwithstanding that, the individual who served the order against trespass has a limited right to appeal the order by bringing a small claims action against the landlord. The decision shall be final and is not subject to appeal. One thing I want to confirm with our legal or judiciary team is whether there should be a right to appeal. This one has a right to appeal, the one that I drafted up does not. Whether there needs to be one, I will confirm that as well.
Okay,
And that could be a simple change. I mean, it would just apply to both. If you're gonna include both, it would just apply. to both.
okay, yes,
So in the situation, my girlfriend lives there, they have two different apartments, he moves out, he's the drug dealer, and he comes back to the apartment and she allows him in, he can, would be trespassing,
under B.
okay.
In other words, A, remember, we have to be careful here, and this bill, I think, reflects being careful. People have a right to association. They have a right to have their friends in their unit, all that kind of stuff. And so we have to be aware of that. Although State v. Dixon, am I right, counsel, was not a constitutionally based, it was based on their reading of statutes.
Correct.
Okay, so we have to be careful. And so this is limited to 3 situations. One is where the tenant themselves says, I don't want this person in here, which is important. They could say that on the QT.
Mhm.
The second is that the invitee, the one who's coming in, is violating the terms of the lease agreement, you know, because they're doing something in violation of the lease. And the third is if they're violating state or federal law. So how do people feel about in the next draft of this thing, if we just put this in here?
I'm perfectly fine with it. I have witnessed the court reading Statute Brown report myself. So. Correcting
Don't
that.
tell them.
I did in the cafeteria.
Okay. Are you gonna tell us more about this?
I was not intending to, no, sir, unless,
You were talking to me?
This-
You're just-
No, yeah, I just noticed he's pointing.
I'm happy to.
We want to hear the rest of that.
It wasn't the same thing.
How do you put it in the lease?
You don't have to put it in the lease. You just put in the lease that it's illegal to do this, that it violates selling drugs or otherwise violating the law is illegal, it's a violation of the lease.
But what if
the tenant is not the one selling the drugs, it's the people that the tenant has allowed to stay with them.
That's what the
That's what
Fennell
this is.
bill is dealing
Yeah.
with, is that,
Because there was a situation where this man let people into his apartment and finally, and they had cameras and all that, and finally she was given a no trespass and disappeared, and he was evicted and moved on. Or supposed to move on.
And it's also, there is in statute 4456, it's about tenant obligations. It states that the tenant, this is in the sub B, the tenant shall conduct himself or herself and require other persons on the premises with their consent to conduct themselves in a manner that will not disturb other tenants' peaceful enjoyment. And and I would even argue the tenant shall not create or contribute to the non-compliance of the dwelling unit. And so I would argue if you're allowing someone to come onto your property who's been selling drugs, that you are violating that section by authorizing them to be there. So.
yes, Debbie.
Back to that thing about having approved drug dealing. Like, I mean,
Under current law, if their lease has not expired and you want to evict someone for violating the lease terms, you have to prove it under current law. This 772 doesn't change the fact that you have to prove it, but it recognizes that you may be difficult to prove because of fear on the other part tenants. And it makes it easier by allowing you to do it by asserting in a affidavit under penalty of perjury that they're doing it. And then the burden the burden of going forward shifts to them. If they come in, so you properly asked, well, what if they come in and say, no, I didn't, and I've never done this, and those needles aren't mine, and I don't know where you're coming from and all that. Then it's really up to the judge. If the judge feels like, yeah, like that's nothing, the judge, he or she can just order them out right then. If the judge thinks that there's really a possibility that then they have to, under 772, they have to have a hearing within 30 days and just decide. It's not ideal, but it is the best that people could come up with that's better than what there is. Yes,
Do we know when someone calls the police? I know they ask you for your name.
Yeah.
If you have a complaint, is that confidential or they can let it?
it's interesting you raise that. Let me tell the committee about a request that's come in. People are talking to me in writing. I mean, I don't know if you've noticed, we've gotten a lot of letters, okay? There's a certain amount of interest.
Yeah.
Anybody notice that?
Yes.
Here was the request. Apparently, and this is counsel, I really don't know the law on the subject. The request had to do with what if someone dials 911 because of a problem? Are the recordings, when are the recordings of 911 confidential and when are they allowed to be used and by whom? I don't know the answer to that, and I'll have to talk to the individual. I think the concern was something might be said that could be used in an ejectment action, and it should be confidential. But could you just check to see what the law is on a confidentiality even before I bring that back to the committee? I don't know. I don't know.
Because if that was confidential, it might make it, give them more apt to.
More apt to call, yeah. I don't know whether it's a big concern that, oh, I can't dial 911 because. So here's a fairly large issue. It's large in the sense that it is a difference between substantial difference. Current law does not give tenants a particular right to purchase property when it's being put up for sale. So in other words, I'm a landlord, I want to sell the property, I just can put it on the market and sell it, okay? 440, and correct me if I'm wrong, counsel, I think 440 and maybe 339.
I think it's just 399.
399, not 40. Really? It's just 399, okay. 399 says, no, there is a right of first refusal, et cetera. And it contains in it a lot of procedure. And I will tell you that if you decide that you want to allow this, you can't avoid the procedure. In other words, if you really are giving someone, it doesn't matter what the context, it's not just landlord tenant, you give anybody a right of first refusal. You have to say, how long do they have to exercise that right? And then how long do they have to negotiate and raise money? Okay. And in the case of 399, it's 45 days notice of sale, right? And 45 days to negotiate if they say yes. In other words, let's say you want to put the building up for market. You can, but you cannot accept any offer. Right? You can't accept an offer for 45 days. You have to let the tenants get it together. And then if the tenants say, no, we're not interested, that's the end of it. You can sell it. But if they say we're interested, then you have to give them another 45 days to do it. I just want to know how you, that's not in 772 or any of the other.
And I would just comment that it's currently there is a similar right to purchase for individuals who live in a mobile home park.
Mobile home park. Yeah, that's how, yeah.
This is modeled off of that.
Yeah, this is how Gail's organization exists because of that rate. It's not nuts, okay? These happen. The complaint against it, the reason for it is to give tenants a right to do what it says. The argument against it is landlords say it doesn't happen very often, and it just means all sales are held up for 45 days and maybe even 90.
And I was just saying, just one clarification, there's the 45-day period where the, residents would provide notice that they want to purchase. And then if they do provide notice, it's 120 days that it has to be held.
Oh, okay. So it's longer, yeah. Which, by the way, I mean, you may decide we don't want to do any of this. I am not advocating for this. I did not put it in 772. But if you want to do it, I'm telling you, you have to allow the time. Because if you really want to allow people to purchase something, you have to give them time to raise the money and put the deal together. Okay, you may feel that this is not something you want to do at all because it's unduly burdens the transfer of property for a landlord, or you may. Didn't put it in 772. Debbie.
I mean, we've never had this situation, but my feeling is if you're putting something on the market, they could purchase it off the market. I mean, they could do the same thing without doing first refusal.
They could do what?
In
They
other
could
words,
purchase it,
Purchase what?
the property that
property.
you're putting on the market.
yeah, in other words, she's saying tenants can always purchase it. What a right of first refusal does is it constrains, in other words, yes, they could always purchase it, but the landlord could always say, I'm not selling to you. Or they could say they can purchase it, but usually a right of first refusal has a process in it because it has to allow people the time to get the other tenants to agree and raise the money. But this is again something where there's nothing wrong with either, intrinsically wrong, it's simply making choices. if you really believe people should have a right of first refusal, generally speaking, to make it real as opposed to theoretical, you have to have a lot of time in there for them to
And a
raise.
plan.
And a
structure.
plan and all of that. And existing law in 772 just doesn't bite off that out.
Mhm.
And nor does 440, right?
Correct.
Thoughts? I didn't put it in 772, it's just not there. I mean, Debbie's right. There's nothing, don't get me wrong. There's nothing preventing a consensual agreement between a landlord and that's what happened.
And what?
A tenant. The old, yeah, I mean. I hesitate to mention it, but there's this store in East Callis that you might have heard of. Where we were a potential buyer and the landlord owned that building and we wanted to buy it and they we wanted them to give us time to buy it and enter into, and they wouldn't. And then everything was fine because they weren't doing anything. And then all of a sudden there was some other buyer out there. And we had to like scramble like crazy and come up. We actually went to Northfield Savings and borrowed the money. Talk about going out on a limb.
So,
But that's the situation.
so again, this is like recognizing how tight the market is and recognizing the that there are buyers out there that can pay cash and that the tenants, that it would, they're gonna be in a uncertain situation, right? Because you don't know whether the buyers are gonna keep renting to them or not. I think I kind of like some kind of buffer, of either grandfathering in some of the leases for a certain amount of time, or giving them some sort of time to, if they wanna buy, recognizing their right to try to, protecting the tenants that are in that kind of situation a little bit. And I mean, I guess you could say that, the landlord could have made so much more money by putting it out on the free market. But they can set a price and the tenants can say yes or no, we don't, we can't or we can't pay it. And then once that time is over, it goes out to the free market. And then if by then the tenants have raised enough money, they can compete, to bid on the property.
772, I realize, does contain some of that protection in that it gives them tenants a 90-day notice of sale,
Right,
Of
not the
sale.
right of first refusal. Yeah.
not the right of first refusal.
Yeah.
How much time are you giving for that?
90 days. Oh, there's no right of first.
Okay,
They're
It's
just
not in
giving notice
772.
90 days if the landlord is rational and just as interested in money. If the tenants then have 90 days to raise the money, but it's not a right of first refusal. And the right of first refusal, council tell me, is there's no quantity in there. In other words, they have a right of first refusal, but if someone offers more, the landlord's free to say no, right?
They may have to allow for a counter offer, but they're not required to reject a higher offer simply because you have the right to make the first offer.
Right, all it is a right to make the offer, which one has anyone.
Yeah, that's not what a right of first refusal is, right? Isn't it like?
No, but there's no amount.
Yeah.
That's-
so then how can it have any validity if you don't have any framework?
Answer. So it is not complete. if I negotiate a right of first refusal, okay, if I actually negotiate it, not in a law, I will put a price and a time. This does not, the 399 doesn't have
It
that.
doesn't?
I don't think so.
There's a lot on the right of first refusal. Maximum increase, tenant rights to purchase property, it starts on page 11, 12, 13. 14, 15, there's a lot in there.
So it says that the owner shall, among other things, accept an offer from the tenants or nonprofit corporation if the offer equals or exceeds the appraised value of the property or is on substantially equivalent terms and conditions as the best reasonable offer from another third party.
So if they match somebody else's offers, it will even prevent other people from putting in
Yeah.
offers.
But you shall accept an offer that is,
Under the 440, under 333.99,
no,
if,
I couldn't afford my house if I had to buy it at its current appraisal value.
Yeah.
I'm just saying like,
but if, anyway, how do people feel about this? I did not put any of this.
So you're
the
saying
appraisal of
it's
the town
moved?
value versus the bank's appraisal.
No,
Well,
it would
no,
be,
'cause it
no, it
also
would be a
says-
bank.
It'd be the bank's appraisal.
Yeah.
Oh, okay.
And it says if there's a matching, if there's
Current
another
appraisal.
offer, and it's saying they'd have to match
I mean,
another offer.
Let's say it's praised at $500,000. Or let's make it, it's a multifamily building. Let's say it appraises at $1 million. If the tenants come in and offer $1 million,
Yeah.
the landlord has to accept that even if someone else offers 1.1 million,
Oh,
right? Yeah. And I didn't put any of that in there. I didn't do it. I will now stop attempting neutrality and be an advocate. I'll tell you why I didn't put it in. Generally speaking, I'm trying to avoid situations which are unlikely to materialize, but have the effect of hurting all the time. And I felt like it would be very rare that a collection of tenants could afford to buy a building. And that, on the other hand, if we put in 45 days and how many? 120?
120 after that.
Yeah, we were really meaning that we're just putting a major burden
On sale.
on the sale if tenants thought, I mean, basically, if there's 5 tenants in the place and 1 or 2 tenants, well, I don't know, is it defined what triggers that?
Oh, I think it ends up having to be a majority.
Majority of the tenants. I mean, it doesn't take much to get people to say, sure, if you could say, listen, it'll let us stay in here 45 more days. Doesn't take a lot for people to just sign. It's not like they have to put money on the line. Then they have another 120 days to come up with the money. But I did put in 772 a 90-day notice, which means that there's 90 days to try to raise money and make an offer. But it's more consent. 772 relies on consensual behavior of the landlord and the tenants. 399 is in the law. Well, we can park this while people think about it. We've done a lot today. And we have more coming, and we are now at 2:30. We're moving on to, right? 2:30. I can see people are sort of agitating on this. Is it 2:30? You're taking a break at 2:20, which we passed, and 2:30. 2:30, we have
Have a wonderful evening.
yes, we're talking about the AFL-CIO investment trust update. So guys, don't forget this up again. And the other issue that I want to bring up, just so you know, is 1 or 2 of the bills have a right to counsel for all tenants, and 772 and 6 599, what's it?
688.
688 doesn't. And 772 doesn't. We'll deal with that when we get back to this. But we are we are getting there with this bill. We're getting there. Okay. And I really appreciate everybody's attention, and I appreciate people's desire to try to work it out. I'm hoping, since we all agree that the current situation is bad, that we can come to an agreement which would be better. And then if we have to revisit it and make it even better later, we will. But I hope we don't just end up with the status quo, since nobody seems to like it. I don't.
Agreed.
All right. So, ladies and gentlemen, we are now moving on to housing housing initiatives. And particularly, we're off of the landlord tenant issue.
Yeah.
Do we have your witness online? He's online. This is, I'll just announce the subject. JP, are you going to introduce this? Okay, you want to come take the chair? This is a very interesting development that JP has talked to me about before. And I was always curious about it because it's a potential source of money in the housing arena, of which we do not have enough. And I'm sure it involves labor, it involves labor agreements or something, but nonetheless, it's a source of money. And I was always curious about it and never had time to research it myself. JP kindly said, well, I can arrange for a little testimony on the subject, and that's what this is. So JP, you want to tell us your name for the record? And you say that Eric is online?
I'll be online, yeah.
Okay, great.
So my name is JP Isabel. I'm the executive director of the AFL-CIO. I'm here today to talk about the AFL-CIO Housing Trust, which is a separate entity from the National AFL, but obviously a partner of ours. Thank you to the chair and to the committee for your time. And Eric is there, so I want to thank Eric as well for his time, his patience. This is something that our president, Larry Moakman, who we've all met, actually brought to Senator Sanders a little over a year ago now. And it's something we've been working with his office on, the treasurer's office on, and developers on to bring this investment to Vermont. The HIT invests in housing projects that are built with 100% union labor. And as I said, we've been meeting with various stakeholders in the state, looking for the right project, looking for a partner to work together on this issue with. And I thought it'd be great to have you guys learn more about not only what we're doing with HIT, but what other states have been doing with HIT, creating funds that essentially kind of create these revolving funds that you're able to access over and over again. And they provide subsidy to the housing that then makes it easier for the developer to build. And I handed out an op-ed that was recently published that was written by Larry Moakman and the building trades president, Matt Glavin, about two projects in Burlington where union labor was not selected. We bid for the projects, but we weren't selected outright. One of the projects is the Burlington Square project, which is kind of the pit that's been there for a while now. And the other project was actually Burlington High School. With the Burlington Square project, the first tower went up and they had all sorts of issues. The general contractor was not happy with it. In came some union folks, and the ironworkers came in, completed the second tower ahead of schedule. And actually then they had to have the plumbers and pipe fitters come in to revamp all of the design in those buildings, given the issues with the first building. And then with the Burlington High School project, we all know that that's come in under budget and is ahead of schedule. And so those are examples that union labor is at work in Vermont. We know we have the labor. I understand that there is a labor shortage in Vermont, but we feel very strongly that our union partners can step up and come to the table to help us meet this crisis in Vermont. I know you guys have been doing a lot of work on housing, and there's a lot more to be done. And there's a lot of good momentum building, and I think HIT can be a part of our solution here in Vermont to help build new housing, grow our economy, and really create family sustaining jobs. So I'll turn it over to Eric to have him explain more about HIT and what they have done in New England and across the country.
I'll tell you what, Eric, why don't you just give us your name and then we'll introduce ourselves to you.
Oh, wonderful. Well, thank you so much. Well, my name's Eric Foreman, Director of Housing Policy at the AFL-CIO Housing Investment Trust.
Okay, Debbie.
Oh, I'm
Start us.
okay. I'm Debbie Dolphin. I represent St. Johnsbury, Concord, and Kirby.
Hi, Tom Charlton, Athens, Chester, Grafton, and Wyndham.
Joe Parsons, Newbury, Thompson, and Groton.
Leonora Dodge, Essex Town, City of Essex Junction. Hi.
And I'm Mark Mahaly. I represent Plainfield, Calais, and Marshfield, north of Montpelier.
Welcome, I'm Mary Howard and I represent Rutland City District 6.
Gail Pezzo, Chittenden 20, Colchester, welcome.
And Saudia Lamont is online. And Saudia, you want to introduce yourself briefly? I think she might have stepped away. Where are you? Eric, where do you live?
I'm based in New York City.
New York City. This committee it's called Housing in General. It deals with the general, includes labor. And the interesting thing about the committee is that Vermont has what might be called an urban area in Burlington, although it's a small urban area as the nation goes. And then it has areas like where I'm from that are sort of rural, and then it has extremely rural. And you've got a bit of everything in front of you here with this group. So take it away and tell us about this program.
Well, thank you so much, Mr. Chair, and thank you to everybody for the opportunity to be here today. It's truly an honor. I'm a big, I guess you could say, fan of the state of Vermont. Haven't spent as much time in Vermont as I'd liked. I'll take a risk and tell you my grandparents for a time lived in New Hampshire. And so it was always sad when I had to make a turn off to New Hampshire. Well, not sad for go to New Hampshire, not sad to see my grandparents, but sad to not be able to spend more time in Vermont. But I'm here to obviously share about the AFL-CIO Housing Investment Trust. So let me jump right in. I went ahead and wrote out some prepared remarks. So I'll try to keep it lively and not read off the script. And then I'll also share my remarks after, so you've got something for your files. So I'll jump right in. So again, my name's Eric Foreman, Director of Housing Policy for the AFL-CIO Housing Investment Trust. The AFL-CIO Housing Investment Trust is a $7.3 billion social impact mutual fund that invests union pension dollars in the construction of affordable housing built with 100% union labor. HIT is unusual as an investment fund in that we have our roots in the civil rights movement, specifically in the conversation in the mid-1960s between Reverend Dr. Martin Luther King Jr. and AFL-CIO President George Meany on how union pension dollars could be used as a tool to promote equal housing opportunity. Those are our origins. 6 decades later, the AFL-CIO Housing Investment Trust, or HIT, and its subsidiaries have invested $11.6 billion in 630 projects all across the country, creating 131,617 units of housing, which has generated $51 billion in total economic benefits, $6.9 billion in tax revenues, and 215.5 million hours of union labor.
How many, you said 11.6 billion in 630 projects. What was how many units or how many housing units? I think you said, I missed it.
131,617 so far. And we have approximately 40 projects under construction right now across the country.
Okay.
HIT's model of impact investment. So these numbers tell a story, but they don't tell the whole story. HIT's model of impact investment does not only get housing built, it helps lift up entire communities and drive equitable economic growth. In doing so, it provides a holistic solution to the affordability crisis, both creating affordable housing and ensuring that workers involved in building housing can themselves afford a place to live, and creating high quality jobs to attract the skilled and trained workforce that you need in order to meet the needs of the housing crisis. So we've proven that model works both nationally and in neighboring states such as Massachusetts and New York. In Massachusetts, HIT has invested $876 million in 45 projects with 5,405 units of housing. 95% of that is affordable housing. That has created 23,384 jobs and generated over 700 million in tax revenue and over 5 billion in economic impact. In New York, the other direction, HIT has invested 2.2 billion in 80 projects that have created 45,444 units of housing. 91% of that is affordable housing, created 30,188 jobs and generated 426 million in tax revenues and 6.7 billion in total economic impact.
Can I interrupt you and just ask a question? You said 91% of the units were affordable in New York. Is the fund, the governing policies of the fund, whatever they are, what provisions do they contain that concerning affordability or any other criteria for what the housing has to meet in order to become eligible besides the labor rules?
The labor requirements are the only hard threshold. However, as an impact investor, we seek to invest as much as possible in affordability and affordable housing. And so we're targeting, you could call it a triple bottom line. One is creating good union jobs, two is getting affordable housing built, and three is generating modest but reliable returns for union pension fund beneficiaries.
What are those returns that you seek?
They're in line with other fixed income investments, which, the returns fluctuate. They are in the typically fixed income mutual fund returns are in the single digit range. But it does fluctuate with interest rates, and HIT is right in that range.
So this is important just for the committee. So the returns are what fixed income returns would be, not what real estate investment trusts would be, which are usually double digit, right?
Yes.
Oh, and by the way, you said in terms of labor, there's not, as I'm sure JP has informed you, this is not what was thought of as a state chock full of labor employment in the construction trades. I assume that when you say it has to be built with labor, am I right that could be a labor, what do we call them, agreement?
Project labor agreement.
Project labor agreement with the contractor, which is not a labor. It's not strictly a labor movement contractor, but it has to agree to prevailing wages or something like that.
The requirement is that the workers need to be union represented, and so we'll defer to the Vermont Building Trades on how to structure those agreements. But generally speaking, yes, a project labor agreement in most cases would meet the requirements that HIT has. It essentially means that the workers on projects are being paid wages and provided with benefits and working conditions that meet the terms of a collectively bargained union contract.
Thank you.
And so that can be done on a project by project basis.
Is this competitive? How do you guys decide who gets the award? I mean, is the project that applies, or is it the local unit? Who applies for the?
Generally, it would be developers who are seeking, we provide the debt for projects. And so it'd be developers who are seeking construction financing, which is typically 65 to 80% of the project cost. So the lion's share of project costs would then come to us looking for financing. And so we've had good conversations with one developer so far in Vermont working on a major project. Definitely interested in talking with others. What we find is that for affordable housing, in general, affordable housing requires subsidy in order to be affordable. And so the challenge we find is that There are many cases in many states where there are subsidies that require labor standards, whether it's prevailing wage or a project labor agreement or use of skilled and trained workforce. But there are also many subsidies that do not, and so for us, once that floor of labor standards is in place, we can get involved and get hands-on and do help move projects forward and provide them with competitive financing. If it's okay, I do have a few more remarks on this. Should I continue?
Please do. When other members raise your hands and we'll go, we don't wait till the end.
Okay. Well, I'll keep reading through, and if anybody has any questions, feel free to jump in. So we've been asked to provide testimony of how the AFL-CIO Housing Investment Trust could bring this model of housing development to Vermont. We have yet to finance a project in Vermont, but particularly in light of Vermont's strong tradition of innovation and affordable housing development, we would be enthusiastic to partner with you to deploy Union Pension Fund capital to help meet Vermont's need for over 40,000 units of housing by 2030, which is what I've seen on the most recent dashboard. As a socially responsible investor of union pension funds, our threshold requirement for direct real estate investment is simple. Projects must be carried out with union labor. To achieve this goal here, what we need from government is to set a floor for labor standards in government-supported housing development. That can take the form of requiring a project labor agreement reflecting collectively bargained wages and benefits. It could take the form of prevailing wage standards, use of apprentices and state registered programs, or other similar requirements. As I'm sure folks are aware here, since the New Deal era, such requirements have been very common for investments in infrastructure and public works, and generally apply to housing development projects that receive federal support in the form of Section 8 vouchers, National Housing Trust Fund, and other capital subsidies or HUD-insured financing. The architects of those programs designed those programs that way because they acknowledge a simple truth, which is that we cannot address affordability by underpaying workers. It serves the public interest when government ensures that public dollars advance the public good. And that was, in fact, the policy perspective that informed what many see as the golden age of this country's growth, the post-war era, where productivity and wages rose in tandem. Unfortunately, in the last maybe half century, you could say some of those lessons have faded, and our economic policies including housing policy, has drifted away from the goal of ensuring that of connecting the dots between the well-being of working people and the health of our economy. It is also well known that there are major problems in the construction industry that have resulted. I'll share some statistics from a recent national study. The estimate is that 1.1 to 2.1 million construction workers are misclassified as independent contractors or paid off the books, which costs taxpayers $5 to $10 billion annually in unpaid Social Security and Medicare contributions, unpaid payroll tax, overtime, unemployment insurance, and workers' compensation insurance payments. This same study, and I'll share a link, estimates that Vermont's share of those costs totaled $95.6 million per year. There are additional costs that come from low wages in the construction sector. Another study found from UC Berkeley that an estimated 39% of families with a family member in the construction industry are enrolled in one or more social safety net program. That costs an estimated $28 billion annually through the provision of benefits such as Medicaid and SNAP. So in an environment of uncertain federal resources, government cannot subsidize developers and contractors that do not create high-quality jobs in our communities. We can also see a very stark contrast between that approach of development, which does not focus on job quality, and HIT's model. Our track record of $11.6 billion invested in 630 projects has generated $6.9 billion in tax revenues. This demonstrates that, and $51 billion in total economic benefits. This demonstrates that there is a better way. An investment in workers pays dividends to the entire community through increased tax collections and economic impacts that catalyze equitable economic growth. Across the country, we have seen that policymakers are increasingly, again, connecting the dots and returning to policy frameworks that create the abundance of the post-war era through state-level tools that bring the benefit of union-built affordable housing to their communities. In 2022, we partnered with the state of Nevada to create, through its recently established state infrastructure bank, to create a $20 million revolving account for union-built, union pension fund financed affordable housing development. So far, as of last year, we made our first investment ever in Nevada, providing $30 million of HITS capital to leverage a $7 million state investment that will build 208 units of affordable housing in Reno. Late last year, the State Infrastructure Bank committed $25 million to build 1,350 units of affordable housing, redeveloping a golf course in Las Vegas into the largest affordable housing project in the state's history, which we look forward to financing. Closer by, last fall in Connecticut, the state committed $50 million to create a similar program, which will create union jobs, build affordable housing, and catalyze union pension fund investment in a similar manner. Similar programs are in the works in cities and states across the country. We would be proud to partner with government, labor, and the private sector to create union jobs and affordable housing financed with union pension fund investment in the state of Vermont. And I'll leave it there.
A couple of questions for you, and maybe you, JP. Would the current state of the law in Vermont allow projects to qualify if they had project labor agreements? In other words, as what I understand from Eric, it's not just that the individual project has to have a project labor agreement, but that the substrate of state law is implicated as well. Am I saying this right, Eric?
The way every state is different with the legal landscape. The way that where we've found success in the programs in Nevada and also more recently in Connecticut is creating pools of subsidy. In both states, that subsidy was generated through a state bond issuance. Generally, it was a larger bond issuance, and a small set aside was then put into a program which was designed to create and had a legislative intent to create high quality jobs in the construction industry and to catalyze union pension fund co-investment. And so the language in Connecticut, the requirement for access to those funds was a project labor agreement, use of a skilled and trained workforce, including apprentices and state registered programs, and in co-investment from a union pension fund or commingled fund of union pension investments with a track record of investing in affordable housing construction. And so there doesn't necessarily have to be a PLA requirement. Another way to catalyze the investment would be to dedicate a pool of subsidy, which requires co-investment from a fund such as HIT, which is not the only such fund, but we are the most, I'd say, have the longest track record.
No, I misunderstood, I think. I think incorrectly that you were saying that it's not enough to look at the individual project, but that the state itself had to have certain prevailing wage laws or other things. But that's not the case. It's the project that matters. Okay.
At the end of the day, it's the project that matters. Generally, though, of the broader landscape of project pipeline, if there are no standards on subsidy, there in Vermont, as in all states, there's millions of dollars, tens of millions of dollars every year in subsidy going into projects. Some of it's money for infrastructure. Some of it is the low-income housing tax credit. Others are, housing trust fund, federal funding, or other pools of state funding from the general budget or bond issuances. Presently, and I'm not the expert on this, it does not appear to me that there are any labor standards on funding going into housing development in the state of Vermont, nor in the recently passed infrastructure package, which, if I understand correctly, is financed through tax increment financing. What that does is developers are competing, obviously, for that money. They're also profit-oriented and seek to drive costs down. It puts us at a severe disadvantage as a responsible investor to get projects to use union labor so that we can provide financing. Our financing is highly competitive, but we're not going to be able on our own to convince a developer to use union labor. That's where we need government to play a role to set a floor. And the reason I've cited some of these statistics about misclassification and costs to the public through public benefits fund payments, if developers do not create good jobs, family sustaining jobs with benefits, ultimately the state's going to be footing the bill for low wages to workers one way or another. And so we've created a mechanism instead where create family sustaining jobs, it pays for itself in tax collections and the economic activity of workers having good union careers.
Thank you. I have one more question, but I don't want to, if members of the committee want to. Should I just go ahead or do you have a question before? You mentioned that you're basically often coming in as a construction lender with a kind of 60 to 65%, and presumably the rest of the capital stack is equity or other sources. How about takeout money?
We also provide permanent financing.
Okay.
Yeah.
All right.
And we work with local banks typically as partner lenders. HIT is the investor, and so it can allow small local banks to provide a lot more capital for projects. We also look to work through state housing finance agencies to provide credit enhancement or to use the government sponsor enterprises, Fannie, Freddie, or HUD for insurance. And that allows us to reduce the cost of capital through credit enhancement, through the guarantees that those institutions provide.
Right. Do you ever take second place? First, you always want to first, or when you work with banks, do you subordinate?
Generally, no. We do have some new mezz debt authority, where for the right project, we may be able to get creative.
That's mezzanine debt.
Yes.
It's real estate, guys. It's this fancy word for kind of
We don't want to be real. It's
something. You don't want to be your. Okay. Yeah, but generally you're first unless you occasionally come in as mezzanine debt. Okay.
Yeah.
And then you take an interest in the developer's single purpose entity.
We're the debt. And so it's not an ownership interest,
Okay.
but we would be lending to that single purpose entity. Yes.
Yeah. Okay.
And typically a developer provides the real estate as collateral. We also finance projects through, it's the last 100 years seems like the story of making financing real estate as complicated as possible. We also purchase mortgage-backed securities, which is another way to provide the capital for housing development. And so, for example, in a deal, let me think of just a recent example. We can even bridge. A lot of affordable housing is financed through tax credits, where a developer gets awarded tax credits. They then, through a syndicator, sell the tax credits, get the proceeds, but the proceeds don't all come in at the same time or when they need them. So we provide bridge loans against tax credit financing. Often that's the equity in an affordable housing deal. We then will, in the same deal, we may work with a local lender to provide a construction loan. We can do that without credit enhancement, a direct construction loan. And on the same deal, we can also provide the capital for the permanent financing, which is the mortgage, once construction is complete, which repays the construction. So we do almost the entire capital stack. Yeah.
This is, by the way, just for the committee, you've heard about our local tax credits, right?
Yeah.
4% and 9%. You know that these tax credits work, a bank or somebody buys the tax credits, right?
Yeah.
But they somewhat less than the credits they get, so they account for the time value of money and profit.
Right.
The problem is very often is the tax credits don't come in on day one. They don't pay up front. They pay, I guess it's, it's usually paid up in the first year or year and a half, but not right away. And so what he's saying is they'll step in and provide bridge financing in advance of the tax credits, and then they get paid back when the tax credit money is paid in.
Yes.
Also, what he's saying is these are all devices that really good, like green banks use in the environmental area. You know, it's same kind of thing. They may do what our treasurer does, which is they'll come in and they'll say to a local, well, they'll just lend money at below market interest, or they will go to a bank and say, you lend the money, Northfield Savings, but instead of lending it at 8%, if we're there backing it in some way, you can reduce we're reducing your risk so you can lend it at less money. This is all very interesting. Why have they not been active so far in Vermont?
That's a great question. Eric, do you want to take a stab?
So I see that I must hit a funny bone here.
Well, I think, I don't know. I think that the landscape has been changing so much in the past few years, and I think that all across the country, cities and states where there wasn't as much a focus on housing, now there is. This conversation started and we got introduced through JP through Senator Bernie Sanders. And we were very grateful for the outreach, and we're also able to meet Treasurer Pichak and others, as well as members of the Burlington city government. And so it's been a lot of wonderful conversations. I think one reason why there has not been a project yet, it could be because there were not so many very large-scale projects previously. That's maybe my guess.
You mentioned one developer. You having to talk, if you're free to say, are you talking to the Ride My Bike people?
Yeah, yes, we've been talking to Jonathan Rose, and
Yeah.
we haven't met Hula yet, but yeah, and we would love to finance that project. I think, the probably the main reason we haven't been able to finance a project yet in Vermont is because I think, like many places where there has not been a lot of residential development, there's also not been has not been a lot of union density in residential construction, simply because that's not where most of the jobs were. But that's changing dramatically. If 40,000 homes are going to be built in the next 4 years, that's a lot of jobs and a lot of opportunity also for impact that can be created through a jobs program. So our framework generally has been to try to look at everything holistically, and as we're building housing, also look at how can we change lives through creating good union careers, which also leads to higher quality housing, safer work sites, and other collateral benefits.
Let me give you an example. I mean, where I'm coming from is I'm here we are in a state in which, as I'm sure you know, labor is less pervasive than it would like to be. And I'm trying to figure out how we might use the resources of the social impact investment. What's it called? HIT, Housing Investment Trust. Given that reality, while let's take a project where we want to use either, let's say it's 100 units, Tom, it's 100 units, just happens to be in a rural area, which might be either off-site built modular housing or manufactured housing, which may be single wides and double wides, or might be much bigger manufactured housing. But in either case, let's just say that the entities that build that housing are not labor. It's not labor. What could be labor is the installation of those projects, but not the building. You follow me?
Yes.
Have you thought about this problem?
Yes, and some things I can share. The building trades in New York City have been very innovative, and about 15 years ago, had a project labor agreement with a modular manufacturer who set up a factory. The workers were union members, and they built modular housing units. I think the challenge with modular has been until, and maybe this challenge will be solved soon in the current housing crisis, generating enough of a pipeline to make it really make sense to operate a factory. Industrial production works when you have large volumes. So maybe that's an opportunity. For HIT to finance a project like that, the first consideration, the number one question on our list is the building trades unions. Are they satisfied with the agreements that are in place? And so we would look for, for us to be able to finance it, I believe we would need the factory itself to be unionized. Which, I think if there's enough demand, manufacturers should welcome that. It's better for the state. There's all sorts of benefits for retaining a workforce. So, perhaps the manufacturer is willing to talk with the building trades about allowing workers to unionize without interference. That might be one question. So not out of the question, but I think it would be a conversation with the Vermont building trades.
Right. Do you happen to know is Huntington Homes union? I assume not. The thing is, so much isn't union here because it's literally just never come across the transom. It's just like people don't even think about it.
And that's what we're trying to fix.
Yeah, I'm sure. Yeah, I'm sure that they probably think they treat everybody very fairly, and for all I know, they would be completely comfortable with an agreement because that's what they provide. That's what they pay.
Yeah, and I think to Eric's point, it is a scale issue. If you're just doing a one-off project, those are going to be harder for us as a union workforce. But the reason I wanted to have this discussion is because I think it can be more than a one-off. And if we can get that momentum going, we can really get some continuity of work and continuity of employees working, on to build a house.
Well, actually, then you should know about a few things happening here. One of the problems we have, well, of course, I'm assuming, I don't know. Do you know whether the major Pennsylvania, for example, the major Pennsylvania manufactured housing producers, are they union?
Eric, is that?
I mean, there's
we had talked to initially.
those guys produce 1,000 houses in a year. That would be an interesting thing to find out. That's one thing. But in terms of the off-site manufactured housing, we've given a lot of thought to that. And there is some question as to whether we want to assist in the creation of another off-site manufacturer here. There's a
Fairhaven.
is it Fairhaven? Yeah.
Okay.
You know about that, JP?
Skyline.
Yeah.
It's you should know. It is a study at this point, but
Used to be a big factory and
Right.
they've been talking about trying to make it into a manufactured modular housing, facility, and it's just this huge warehouse space where they would be keen to have enough demand in a contract in order to push it forward.
It used to be Skyline Industries.
was it a manufactured home? No.
No,
Something
no,
else.
it wasn't. No, I can't remember what it was.
It was
Was it
always,
modular?
What
And
was
it-
it?
it was
was
always
it-
modular buildings. I
I
don't,
think it was modular and went out of business. See, one of the problems with modular, remember everybody, modular is less flexible to fluctuations in the housing market because they have this permanent workforce and permanent capabilities and what you should know specifically is there is under contemplation here and there is a bill under consideration which would allow bulk ordering of off-site modular homes by aggregating smaller orders where a state entity is the aggregator.
Mhm.
Private developers, small developers are behind it, and the treasurer is using its funds, you know about the 10% for Vermont,
Mhm.
it's using its funds as a credit enhancement. So the interesting question, and with the idea of could you go to Huntington Homes and say, build 40 of these over
Yeah.
time? Anyway, you should know that. I don't know at this point. I have no idea whether that's an opportunity that would appeal to either the treasurer or, or the modular developer. Did you have
I
a
would love to, I would love to learn more about it.
Yeah.
It would, for us to be able to invest and support the project, there would need to be a collective bargaining agreement in place with the Vermont Building Trades.
Sure, yes.
But that's
And I
very
don't-
doable. That's been done in many places at this point with building trades unions and offsite manufacturing.
Did you have a question?
We were looking up to see if that was at one point a manufactured
It,
mobile
it
home.
was.
Yeah, that's what it was.
Yeah, and I mean, there used to be 8 in the region. We've had testimony and now there's like 1 or 2.
Mhm.
Other questions of these 2 gentlemen? Yes, Karen.
I have a curiosity question. You mentioned a location in Connecticut. Where in Connecticut? You know,
Oh, in terms of I think,
the location, what's town?
oh, in Connecticut, we worked with the state legislature to create a program last year. And we're currently looking at projects in 5 different cities to use those funds. Yeah,
Thank you.
New Haven,
Other
Hartford, Bridgeport.
questions of Eric or JP?
I would just say on the creation of those things, the manufactured home or the working with the treasurer's office. Certainly that's an opportunity for you folks as well to say, if this is a priority, to say to the treasurer's office, why don't you set aside X for union housing? And certainly, and any other piece of legislation, and you may see something come over from the Senate on this as well.
On this issue or
On union labor and building housing.
when there is public money, like in
Yeah.
ships or something like that?
In particular, I've seen a bill that would give a density bonus to a project
Oh, right.
that uses union labor.
I would think that you might want to have conversations with the treasurer. I'll certainly mention it to the treasurer.
I think that would be helpful as well. As I had mentioned, the treasurer the office has been in on all of these conversations with folks we've been having.
But have you told the treasurer about it?
Yes.
Okay.
I'm curious
Yeah.
whether, have you talked with with any of the contractor groups in the state to
Yes.
talk about sorry, did you guys already cover this? Okay.
No, I mean, yeah,
Tell me what those.
We've been meeting
conversations
with
have been like.
developers, we've been meeting with Champlain Housing Trust, VHFA. Again, we've been having these conversations with Senator Sanders' office and with the treasurer's office.
No, I mean contractors, like AGC and the. other,
Yeah, they
like,
talk to them.
And.
The problem is, it's just not a union environment.
Mhm.
And the interesting thing about this is, I mean, Eric is making all of these policy arguments, which are why unions matter and why union labor makes sense and
Mhm.
socially good and pays back the investment, et cetera. But they're all just pro-union arguments. What Eric also argued.
Dangling a really
brings
big
is
carrot.
that there
is
is
investment
$8
dollars.
billion
Yeah.
investment trust
Yeah,
attached to
Yeah.
this, to be blunt.
yeah. Trust me, I didn't miss the headline. I did
That
not
that
miss it.
changes the discussion perhaps a little bit.
Yeah.
So anyway, this is interesting. Other questions? JP, do you have any more you want to say?
No, again, thank you for taking the time. I think this is another tool that we're not using right now.
Yeah.
There's a way that we can be using it, so I feel like we can get there together, so I hope we can.
Can I ask one more clarifying question?
Please, go ahead.
So, so this would be one of those, like, remove an obstacle or say, do it this way, as opposed to like a big ask that would enable, open the doors to this new kind of investment.
Well, yeah, I mean, in some way, the interesting thing about this is that these guys, just listening to Eric, I can tell you, I taught land transactions, finance and development for years at the law school. And there are so many interesting ways to participate in construction in ways that magnify your money. I mean, we don't have enough money in Vermont. That's our problem with housing. We do not have enough money. I mean, you heard 2/3 of the housing has to be subsidized. We don't have anywhere near enough money to do that. But we can pretend it doesn't have to be subsidized all we want, but it just means we won't be building that housing. So we need money.
Yep.
But when you need money, one of the ways to do it is to use outside money, not to buy the housing, but to inject in ways that are creative that allow the private sector.
You're leveraging.
You're
other dollars.
leveraging it.
Mhm.
And these guys are, I can tell, they have all kinds of, actually, I would say the full deck of cards when it comes to ways to subsidize. I mean, I don't hear any limitations on what you can do. You can even do mezzanine debt. So they really could do probably anything.
Mhm.
And I think the treasurer ought to know that. You know, it may be, I really do think the ride your
Ride your
bike.
bike. yeah.
Ride your bike is a very interesting option.
It's a very attractive option.
Yeah, very attractive.
Three phases.
We're very
Okay.
excited about that potential project.
I think, and I don't think in Burlington, a project labor agreement would be a major obstacle. But
Yeah.
I'm not going to speak to that. You're looking very Cheshire Cat. Any other questions? Eric, I do see you, on the one hand, you allege that you love Vermont. On the other hand, I see out your window what looks like about a 50-story
Yeah.
building.
I know.
So what I think we're going to do is to say that the next time that we invite you to testify, we won't allow you to come unless you're here in person.
Perfect. Thank you. I'll let our
Have to have an
CEO
excuse,
know.
Right,
I have to
Okay.
be there.
right.
Right.
I would say there is no window in Vermont out of which you see what I see out of the window.
Well, you have much more beautiful views out of your windows from my experience in the state. Well, I think all of us at HIT would love to spend a lot more time in Vermont, ideally for groundbreaking and then for a ribbon cutting with members of the union building trades and the state legislature and all of the stakeholders it takes to get housing built. So we'd love to continue the conversation. We can also provide more detailed list of like different ways that states can catalyze investment. There truly is a lot of creativity happening in housing policy right now across the country, and this has been a wonderful conversation as well as the others we've had with the state treasurer and other stakeholders. So we'd love to continue talking.
Thank you.
Thank
Thanks a
you.
lot.
Find a way to do
JP,
this.
have you been in touch with Michael Gahn?
Michael who?
Gahn?
No.
Okay, we'll talk offline.
Okay.
All right. Thank you very much. We are done for the day. We are about to go into on the floor, and JP, don't go away. And
Should I log off?
thank you.
All right.
And
Thank you. Okay.
just for your information, tomorrow we have House floor at 9:30, and then the Vermont Housing and Conservation Coalition, which is everybody involved in affordable housing, is here tomorrow. And we have testimony from them, and then we come back to your favorite subjects. Landlord tenant.
I love it.
And then we are going to hear Friday afternoon, we're going to hear about VHIP. We have Sean Gilpin coming in. So you're ready to go? Okay. Any other final questions, comments before we adjourn?